gee, following Peter's a tough act. I might add that there's people out there like Mr. Stockheimer, and I have a few friends in Minnesota that are, what we say, equally persuasive. For instance, in the same town where we had the stop sign incident, there's a gentleman who's of rather large proportions who also thinks large and was giving a citation for a dog license. And in their endeavor to find a defense, they solicited the state secretary and found out that this city had not incorporated. So they incorporated the name of the city, in this case it's Atwater, Minnesota, in their own name. And when it arrived at the fateful day of court, they indicated that this court lacks jurisdiction as they had no authorization to prosecute in the name of the city. And in this case, the dog went out. So the judge dismissed the case. They immediately went back and started a harassment campaign against this individual and had ticketed his parked car. In Minnesota, it's illegal to park a car in the wintertime on the streets after it snows. And they saw to it the car was there. And the ticketing process began, and again, the same result. This individual is tenacious as a bulldog, and he will not let go. The last event that Jimmy was in, they towed his implement of husbandry. He's in this drive travel issue. And he had, what we say, persuaded himself that he could use his implement of husbandry in any manner appropriate. And he did, and the local police officer followed him some distance out of town, about a mile, pulled him over into a private entity's parking lot, and proceeded to arrest him and do all the rest of it. When they got him to jail, the sheriff refused to admit him. That's the effect he has on him. They literally made the policeman take him back home. You can't tolerate it. And he's just a big sugar daddy. I mean, you know, he's the sweetest guy you ever wanted to meet. Now, the other side of that story is they had towed his pickup, and he does the, what we say, the commercial lien sense. So at this point in time, this old decrepit, I think it's 74, 75, junker is costing the guy who towed it $100 a day. And it continues to go on and on. And I mean, this is the type of tenacity. I think Mr. Stockheimer is to be commended. What he does is sometimes difficult to understand, but he's very, very determined. And that's what's effective. Now, as to me, I have, what we say, some experience in the courtroom, not all of it pleasant, but for the most part, through the years, I went, what we say, tooth and nail with the establishment using the rules. And most people realize that if you're in the courtroom and you don't walk their walk or talk their talk, you're up against the wall. So I developed what I call affectionately the false witness defense. And basically it's a method of phraseology indicating that whoever asks you a question or approaches you with a claim, you respond with, "How may I help you?" Now, it doesn't sound like much until you happen to be the police officer, and this sort of scenario goes something like this. I was headed home. In Minnesota, they have what they call a sugar beet harvest, and I was coming home late one night at a rather rapid rate of speed, and the policeman thought that I was also going too fast, and he stopped me. So the red lights come on, and he comes up to the automobile, and the first thing most policemen want is some form of identification. So again, keeping in mind, "How may I help you?" is the method of doing this. I asked him, "How may I help you?" And he said, "I need some identification." So I told him to look in his pocket. He wasn't at all pleased with this, but he asked me if I knew how fast I was going. And I said, "Well, given the conditions and the fact that you're behind me, it wasn't fast enough." So then he gets, what we say, a little bit more outraged and insists that I, what would you say, explain to him whether or not I knew that I was going 105 miles per hour. I said, "That's bullshit. This car goes faster than that." He went back to the police car and he called in to see where the automobile ownership was. And a couple of minutes later, he arrived back up at the side of the window and he says, "You better slow down." And I went home. Now, this is a result of developing this concept whereby anybody who inquires of you, you respond in kind. I think that Christ led the example. So he was asked, "Are you king of the Jews?" And he said, "You said that." He said, "What's the greatest commandment?" And he said, "What's the law say?" If you follow that same concept, and it works very well, believe me, unless you have some judge that wants to throw you in jail for contempt, in which case it still works. but you'll be in jail. So you have to watch what you're doing. We had this occasion or I should say more than one occasion. We had a gentleman in Kansas who does this in part, and he's had a real good time with it. Last time the policeman stopped him, it was, the time before the last time, now he was just got out of jail. He was stopped for speeding. Highway patrolman met him on a divided highway, flashed on the red lights, turned around, and he pulls his car all the way off the road into a farmer's field. And the policeman comes up there and inquires him for his identifying certificates, etc. And he says, well, what's the problem, officer? And he says, well, you were speeding. He says, was this a criminal investigation? And the policeman said, well, of course it is. He said, but would you punish me for exercising my right not to be compelled to give information which would be used against me? Now, what it is foxtrot. This man has hit the brick wall. There's no legitimate way of the police officer proceeding other than to punish you for exercising your right by remaining silent. So while the officer swears an oath to uphold and defend, i.e. says that he will not compel anyone to give information which would be used against him in a criminal case, on the one hand. On the other hand, if you don't give them information, they'll jail you immediately. So this is how the false witness defense works. My wife and I had the good fortune of being allowed into an arraignment, and we decided to play this thing to the hilt just to see what would happen. And I had received some bogus citation. I don't recall what it was offhand anymore. Anyhow, I decided I'm going to see what would happen if you carried this to its ultimate, without identifying yourself or anything. They had written me the citation, which was written in my name, and I had showed up at the clerk of court's office the day that court was to convene, and I presented myself, and I said, where are the witnesses and the accusers, and where are the accused supposed to sit? Are they separate? And as we walked in the door, there's, everybody's lined up to go into this sheep shearing pen. And they said, well, what's your name? And we'll see if you have a citation. I said, well, aren't there a place for accusers? Or do you have to compel or be compelled to accuse yourself? And they were, what? So they got this assistant county attorney out there to explain this all to me. And he comes outside and he says, oh, do you have a citation? I said, well, if I told you I had a citation, I would be admitting that somebody had accused me. I'm not willing to admit that I'm the accused any more than I'm willing to accuse you of doing so. Now, it sounds a little bit tough to grasp. Well, he doesn't think so. But if you grasp what's going on and you walk in this courtroom and you wouldn't make these admissions, they've got a real problem. And it is getting to be a problem the more people that are taught this. Basically, the scenario goes, they'll call all of these people up there, and they'll generally in one, what we say, fell swoop, read you your rights, you have a right to remain silent, etc. And then they're going to punish you if you do that. But what would happen if you walked in there and said, as I did, the judge called my name and said, Dwayne Rogers, and I said, I didn't accuse. And you could hear silence in the courtroom. They said, well, there's Dwayne Rogers here. And I said, I didn't accuse. They said, well, are you Dwayne Rogers? I said, are you asking me for admissions and confessions? Is there a punishment for being Dwayne Rogers? Why would I want to admit to being the one who's accused when it's not my burden? The burden of proving or saying who I am is on the accuser. Now, who accuses? He was angry, and he was so angry he slammed the gavel down and left the courtroom. Now, I'm an arrogant man, and I don't take kindly to people leaving my presence without my permission. So I immediately hollered at him. I said, come on back. So my wife almost fainted over this. But now, of all things, I've got a friend in the courtroom with a movie camera. That's a no-no, by the way. And my friend is one of these people that just loves to do this sort of thing. So they won't let him have the movie camera on, but he secretly has clipped this thing on. So the audio is playing, even though he's naming the camera to anybody. In any event, they were so intimidated over this, they went through the routine of asking me who I was again. I said, look, why don't you read the list of people who were supposed to be here? So they go through this again, and when he gets done with the list, when he gets to my name, I say, I didn't accuse. And he said, we have been through this, and we're going to issue a warrant, a bench warrant for anyone who didn't show up. I said, who are you going to say didn't show up? Biggest problem we ever saw. They actually let this thing out, and a few weeks later they notified me for arraignment again. And I thought, well, I wonder what they've got up their sleeve. And this time they had the policeman there. He's allegedly the accuser. And I let this thing go on, and of course this is right up my alley. I love this sort of conflict. So this gentleman comes up there and they get my name and they said, Dwayne Rogers, and I said, I didn't accuse. And the policeman got up and said, I do. And I said, well, before you can give testimony in any court, you got to be under oath. Is this man under oath? And he said, well, no, he isn't. Then he doesn't stand as accuser. Now the problem is, they're going to put him under oath. And I said, well, there's a condition. If he's the witness for the injured party, then he's not the accuser. If he is the injured party, then obviously he's got a fact problem because he didn't claim it. Put him on the witness stand. And if I call you as a witness, I get to lay foundation as one of the facts of life or the facts of law. If you lay foundation in a certain way, you really louse up the program. And I would submit as an adjutant to it. If you're ever stopped by a policeman, you call him as a witness before the prosecution can, because you can lay foundation. And here's what happened. We put him on the witness stand, and he dutifully swears to tell the truth, the whole truth, nothing but the truth. And put him up there, and you ask him his name and whether or not he's the injured party. If he's not the injured party, is he aware of an injured party or an injury or a damage? Answer to all of those are no. Dismissed. Now the problem with that is the prosecutor cannot ask him anything beyond his name whether or not there's an injured party, unless the judge, who Peter pointed out is your enemy, intervenes. Of course, nobody can testify in any judicial proceedings unless he's under oath. So you have to ask the judge to state his name for the record as a witness, which he won't do. At this point, the whole hearing ended again, and we left it. Now, we went back actually 5 times to this, and they elected to dismiss, which quite angered me because it's not an easy thing to get these questions answered. Nonetheless, as you go through this, and as Peter pointed out, I work with people who are either going to be brought before a grand jury or are going to be indicted by a grand jury. And if you can get the right formula out there, and this is a matter of internalizing this, if you get the right formula out there, you can literally respond to any inquiry without telling anybody anything. And it's really not as difficult as you might think. It's a matter of, are you self-deceived, and whether or not you'll admit it. I had a federal district court judge throw me into jail because the first thing I did when he asked me to swear an oath was tell him quickly that I'm a compulsive pathological liar. And I'm damn good at it. Now the problem is, he swears you to that, and I don't take oaths. First of all, would I be telling the truth? And second of all, what makes you think that a compulsive pathological liar even knows what the truth is? Strangely enough, if I told you that I was a liar, would I be telling the truth? He said, I'm not going to play word games with you. I said, sincerely, I don't play games. I'm serious as a heart attack. The problem here is that the scripture teaches, for those who've read it, that swear not at all. Not by any form more than yes or no. So now the question as a matter of law is, when you do affidavits or certifications or affirmations or give oaths, if you will, anything more than yes or no. So technically you're speaking about anything that would modify your response or cause somebody to believe your response more than they would if you hadn't said it. So such things as avow or promise or certify or declare, anything more than yes or no. So it's called embellishment. Now, did I embellish when I said I was a compulsive, pathological liar? I learned this from a guy named George Gordon, and I had always hoped to be able to try this out. By the way, it landed me in jail, which was a good place to be at that time, but nonetheless, when the occasion came about, I thought about it because this judge is very, well, I call him wicked, because he could see through my little facade, and he knew he just had himself a little greenhorn, and he was going to, toss me in the can. The only thing he found out is that though he knew what to say and what to do, those in the prison system did not. And they were really, really angry with me because I'm not an easy man to convince. In other words, if you wanted me to sign in, I'd say, what benefit is it to me? Everybody signs in, they would say. I said, well, you'll notice that I'm not in that category. My name is neither everybody, and nor have I signed in any place before. They don't take kindly to this sort of rationale. But anyhow, back to the judge. As soon as I told him I was a compulsive pathological liar, he decided that I had to take some sort of official affirmation or oath. So if you know anything about language, the word affirm is a synonym for confirm or ratify. And there's a sneaky way of getting around it if you want to, and I used it later, but not there. I told him, I've already told you that I'm instructed to not bear false witness. more than that, I can't tell you. He says, well, are you going to tell me that you're going to respond to every question in the same manner? I said, you haven't asked me any questions. How do I know? So then he goes into this thing, because most people say, I'll let my yea be yea and my nay be nay, which is a euphemism. It's not a direct, because if I ask you how old you were, you couldn't say yea or nay. Or you might, but it wouldn't be appropriate to the inquiry. And then he said, well, are you going to answer it all? And I said, well, I'm glad you asked me that question. You see, the word answer is etymologically connected to and swearing. And I've already told you I would say not at all, which is how you say swear. To say 7 times is to swear, or to sevens oneself, as the old saying was. Now, I would not answer any question, but I would respond appropriately to any inquiry. So now he's mad at me. He says, I'm playing word games. I said, everything you know, every thought you think, is thought and said by words. Every legal writer used the dictionary and words, and he specifically clarified every sentence. Otherwise, he wouldn't have a court case. So it's not true that I'm playing word games. I'm saying I don't understand. I'm stupid as a box of rocks. What else could I tell you? We went on to this thing, and he said, if you're not going to affirm or swear an oath, I'm going to throw you in jail. I said, I can't do either one. I already told you. So he thought, take him away. Now, they don't give you any time in federal court at all. They have 2 marshals like vultures hovering there, and they drugged me out so fast I didn't even know what happened. Now, I had some friends there that slipped my girl out of the building, because my wife is paranoid of these people. And I went on down to their federal prison lockup and spent the day with in the company of some of the biggest, ugliest, meanest, baddest looking black people I'd ever seen. They had the occasion at this time to prosecute a street gang called the Bloods and the Crips on drug charges in Minneapolis, Minnesota. So my cellmates and they were in there waiting for the jury to return. It was rather a bizarre sense, because like I said, I'm a cocky man, but I'm not exactly stupid. And I walk in there and I know what they're doing this for. They're going to get me punished real quick. So I follow the principle that says that you're not to know what you're going to say. You have to study to make yourself approve. These U.S. Marshals, by the way, are quite overcome by what's happened. They don't understand why the judges jailed me when I plainly told them what I wouldn't do. In any event, they opened the door and dutifully put me in, and there's these big black men ranged around the room. And this is a rather large holding cell, and everything is sterile plastic in there. And so they're up there, and they're really quite foul-mouthed. They're talking about this niggers problem, coming up with this honky jury. Excuse my use of the street language. Because he's saying, I'll bet you they convict this black nigger's ass. And I walk in the middle of this, and they see only this little white man actually dressed in the same uniform. And I didn't know what to say other than I could have dirtied my drawers. It was bad timing. I said the dumbest thing anybody could say. And this guy kept loud-mouthing, saying, this damn nigger's going to jail. And so I said the only thing I could think of saying, which is to use the word nigger. And I said, sounds like a nigger in here. And you could have heard a pin drop. But you could have heard me. But nonetheless, they jumped down and hovered around me like they were going to take me apart, and they probably would have, except I said the next thing that came to my mind. I said, haven't you read the scripture? Doesn't it say he created in his image? Do you think God created niggers? Within 10 minutes, these guys were sitting down learning how to write habeas corpuses. And I'm sitting there, what is this? What's wrong with me? Why am I in this predicament? They then, after we had spent some 2 hours in the cell together, were rattling this door, here's a habeas corpus, I want this delivered to the judge. They then drugged me out of that cell and took me out for interrogation. They wanted to know what I was being held for, because they were sending me off to federal prison. And I did the strangest of all things. Now remember, the concept of the false witness defense is to ask questions. So they said, well, you have to be fingerprinted. And I said, well, I wouldn't do that. You see, it's my fingerprints, obviously, or you wouldn't be asking for them. The law in this country says that nobody can be denied his life, liberty, or property without due process of law. And due process of law allows for the matter to be heard and determined before the taking. What, if you will, judgment do you have allowing you to take my fingerprints? Well, we do it to everybody. No, I wouldn't do that. I'm not everybody. And you'll notice that I haven't volunteered, and you've admitted they're my fingerprints. So then they wanted to give me this mugshot thing, same routine. I said, I would give you the mugshot because it's my property, and I can't give it away, and you're not paying me for it. It says there can be no taking without just compensation. Now, strange enough, the Chief U.S. Marshal, whose name was Swenson, really a nice guy, but he was really broke up over this thing, offered to, what we say, make it easy on me. So they went up and got a court order from the same judge who threw me in there. His name is McLaughlin. And McLaughlin issued an order, and I have a copy of it yet, that said you can use all necessary force to get my fingerprints and my photograph. And I was dumbfounded. So I asked him the next question, which is always what I do. I said, how much force would be necessary? Would you kill me to get my fingerprints? He said, no. I said, I ain't giving them to you then. How audacious can you be? They went and got the order, and the judges plainly said, but the problem was, it's not a lawful order. And no one is compelled to obey an unlawful law. So then they tried to negotiate with me. And I said, well, would you break my fingers? He said, no. I said, I ain't giving them to you. And this one guy is rather large. And afterwards, this is a strange story and I'll add to it, but afterwards he came out to my farm place where they raided me, the SWAT team on me. But at that time, he was quite aggressive, and he literally, his hands as big as my little head. And he literally, picks me up and slams me over in the corner and says, look, fella, we're only doing our job. I said, well, what is your job? Does it involve breaking fingers? I wouldn't want you guys to do anything you're not paid to do. Show me in your job description where you're paid to break fingers. So when he started getting them, they started, actually asking me questions. So, well, what religion do you belong to? I said, well, it's obvious you haven't read a dictionary in a while. You see, the word religion is broken down etymologically with RE, which is the first two letters, and RE is a prefix word used in the English language to represent from or before. Oh, wow. Yeah, good ones. It means referring to, relating to, or relating back to. If you look at leg, or L-E-G, it comes from the Latin, which means belief, which is taken out of the Greek lego, which means lie. So religion, alliterated, would mean referring to or relating to the beliefs and the lies of the many. Why would I do that? See, what you're asking me is what my spiritual belief and training is. And my spiritual belief is such that swear not at all, by any form, is what I seek to practice. Now, I've fallen short of this many times, and I'm probably better at lying than most people. On the other hand, I'm probably better at telling the truth, too. So we don't know. If you're a compulsive pathological liar, you get away with either one. At any rate, they then agreed, and I said, look, I want to make a deal with you. I want to know that if I went in front of a jury after I sue you people for doing this to me, whether or not you testify you forced these fingerprints in this photograph out of me. And he said, well, we certainly would. And I thought to myself, this is too good to be true. You can't do this. So they took my hand, and they went to vote on their ink pad, and I started screaming. Oh! And he said, well, what's the matter? What's the matter? I said, well, how would it sound to the jury if you testified that you forced it out of me and I never uttered a sound? Wouldn't it sound more believable if I said I screamed and howled? It got such a bizarre reaction from them, they both agreed to testify. Now, this actually came out later on. And with the photograph, they did the same thing. They literally, the big guy, the great huge one, took my jacket like this, and so they got my mugshot. And then they threw me back in the cell with my friends. And in the meantime, these guys had been bargaining among themselves whose cell I was going to occupy that night so that I could help them. And the last thing they wanted to do is beat up somebody of my perceived stature to them. And at this time I sat down, and it took me about 20 minutes. I drafted up a document called As If Habeas Corpus. Now the reason it's as if is because the rule of habeas corpus has literally been obliterated from 28 U.S.C. It doesn't exist. The 2255 habeas corpus is a joke, and it requires forms and formula and a fee. And of course, anytime you're arguing in this polluted system, you have to be aware that the fee is designed to accommodate the privilege that goes with it. So yeah, I don't do those things. In any event, in this document, I postulated to the judge that if I had offended in any manner, I most heartily apologize. After all, this is contempt. And the key to contempt is you can purge yourself. In the case of criminal contempt, which is what he had me for, there's a law. Now, my question to the judge was, in a conflict between an individual who wears a black robe and sits on a bench and a native son, does the native son lose all of his rights? Does not the judge swear an oath that says in all criminal prosecutions, all means without exception, in all criminal prosecutions, the accused shall enjoy the right to trial by jury? Where was my jury? In all criminal prosecutions, the accused shall enjoy the right to the assistance of counsel in his defense. When was I afforded the opportunity to have the assistance of counsel in my defense? At what hearing? In all criminal prosecutions, the accused shall have compulsory process for obtaining witnesses in his defense. When was I given compulsory process? He threw me out. He was so shook up, but before he got it, they had blocked me. The underling U.S. Marshals would not deliver it. So I managed to get one of my cellmates to give it to the chief U.S. Marshal. And I mean, that was a madhouse. I mean, it was seconds, and you could hear the screaming and the hollering going on. They can't refuse the writ of habeas corpus, and the U.S. Marshals know it, well, some of them do. But in any event, among all the hollering, they managed to get me on the shuttle bus to the prison. So they put me in this federal lockup portion of Stillwater State Prison, which has a federal portion to it. They bring you in here. If you've ever been into the prison system, Stockheimer has, and a couple of us have, I guess. But you're in for a rude awakening. These are not nice people. They teach you like meat. Now, I made quite a stir when I came in there because I'm not what you call cooperative. And it's the same concept of defense. In other words, how may I help you? So they ring in the door and they say, well, what are you in here for? I said, you're going to have to ask whomsoever put me in here. Oh, what's your name? I said, well, we could play word games with that. I could tell you that's not true. And you could look in your records forever and you'd probably find that for once I told the truth. Not about being a liar, but about telling who I wasn't. In any event, if you can figure all of this out and you don't know who you have, then I suggest you let me go. Well, we can't do that. And if you've ever been into the federal prison systems, they put you in a belly chain, leg chains, hand chains. Remember, my crime is being contemptuous of somebody who was obviously contemptible. And he knew it too. But nonetheless, they get you in there and I ask, well, how long are you in here for? I said, well, it's life in prison. I don't know how long contempt is, but contempt normally, in the civil sense, is purgeable by you doing what the court lawfully ordered you to do. In the criminal sense, they can issue you 6 months contempt, in federal anyhow, at a time. Bring you out and bring you right back in. Will you swear an oath? And back you go. And you lose 6 months after 6 months after 6 months for life if they want to. They call it something like diesel therapy, put you on the highway. In any event, because I'm uncooperative, they have the audacity to do a strip search. And of course, this is almost amusing to me because I won't take my clothes off. And I act kind of shy. They said, take your clothes off. Come on. We haven't even gone out yet, as Peter says. But nonetheless, they don't think this is funny. And they kind of roughhouse you. Well, look, if you're going to rip my clothes, I'll take them off just to preserve my hide. And then they want you to take a shower, and then they want to inspect your anal retentive capability. In any event, there's a woman present. And I said, I can't do that with a woman present. And so the woman leaves the area, and I said, no, there's women present. And they got the drift real quick. So anyhow, they decided it wasn't worth it. I've been in lockup all day long, and I'm going to take the shower, and I can let them look up my little dark secret hole or anything else. So they're really livid with this, and they're so angry they put me in what they call triple lockdown. Strangely enough, a couple of jailers empathized with what I was doing, and so they brought me a mattress and a pillow and a blanket. And the other jailer, who hated my guts, would come and take away my mattress and my pillow. and these prisons are not nice places. So you got this stone foundation that you're supposed to have a mattress on, which there's nothing there. And dinner consists of 2 slices of white bread, I say stuffed with cheese, but it's not really cheese, it's some artificially processed stuff. And I'm not into eating that way. So nonetheless, I passed it along, and one of the other inmates asked me, well, what's the matter? And so they give me this apple. So I at least had an apple to eat. But nonetheless, the concept was every 2 hours they'd come into the cell, and they'd want me to give them information. And the information is such as, have you ever had AIDS? Have you ever had sexual intercourse with a male? Have you ever had diabetes? And on and on and on and on. And of course, I'm not qualified to answer any of those questions. I'm not a doctor. How would I know whether or not I had this? And or the other answer is, well, who would you want us to notify? Who's next of kin? And I said, you don't know who you've captured? So this thing got to be, it's like 2 a.m. and they finally surrendered and put me back in my triple lockdown. Except there's a line of inmates out there waiting. They're saying, Mr. Rogers, can you help me with this? Mr. Rogers, can you help me with that? I didn't get no sleep all night long, and this is ridiculous. In the meantime, this writ of habeas corpus had hit the federal judge's desk, and the order came down to get me out of there. Now the fun began. Because to get out of prison, you have to sign. And I wouldn't sign anything. You have to sign that they took your money. I wouldn't do that. I had 30 cents in my pocket. It took them 6 months to mail me a check for 30 cents. I still got it as a souvenir. But nonetheless, the U.S. Marshals finally came in and forced the prison officials to release me. Because I've got a court date, right? And the judge has immediately arranged for, I think the orders had a previously designated court date, which was convenient. And the marshals finally kidnapped me out of there, and they had this document with a request by the prison officials that I process out. And this U.S. Marshal says, I don't know what you've done to him, but something's really rocking in there. The prisoners are rebelling, and the judge is mad that one U.S. Marshal is about to be fired. And what have you done? I said, I ask questions, and that's really all I do. Got in front of the judge, and he asked me if I was ready to cooperate. And I asked him a question instead. I said, are you going to beat me up and put me where you put me last night? I'd do anything not to do that. And so he released me. And of course, all of a sudden, there are no conditions. Oh, I had to agree to an inspection at my home. Which I said, what the hell do I care? You guys have been in there 40 times, why would I care? Next time they showed up, they had a SWAT team. And I'm going to tell you, when they do a SWAT team on you, it's ugly. My son, who was about 10 or 12 at the time, got woken up with an M16. Actually, he was coming in from feeding the animals with an M16, 3 inches from his chest. And they've got, I live right on US Highway 12, which runs into Chicago here. And they had the highway blocked off for a mile in either direction. These guys are with flak jackets, automatic weapons, the dogs, the county sheriff, and all of the local ones. And of course, I'm quite notorious. Now, I don't know what my alleged crime was, but this was allegedly for that inspection. The cute thing is that they had sent me a notice about this inspection. I think it was on December 4th or something like that, which notice was dated February 3rd of a year not yet extant. Somebody had doctored the dates. I saw the letter after the raid was over, and I went out to the U.S. Marshal's car. I said, now this happens to be the guy that agreed to testify that they beat me up to get my picture in that. And I went up there, and I'm rather foul with him. I tell the sheriff what I think of him and all the rest of it. But I said, this is the type of lying, cheating, and underhandedness that goes on, and you guys are all a part of it. He said, well, not me. I agreed to testify for you, that we beat you up. And of course, the deputy sheriff is sitting there, and he's shaking his head and saying, what? How can you testify that you beat him up? Well, yeah, we agreed to testify. So, it actually got out in the public that these people had said this, so it wasn't just me anymore. But I'll give you an example. We had a incident in, 82 or 83? No, 84, in which I had been arrested for, if you will, invalid license plates. Now, I had no notoriety or anything then, but I knew enough to ask questions at the time. And I asked the policeman what the penalty was for not having valid license plates. And he said, well, it's a $20 fine. I said, well, why don't we go and have a meeting with the magistrate right now? So we drove over to the courthouse, and we caught a judge whose name was Bull, which is appropriate, he's full of it, in a bad mood. And the officer called in and said, we got a Mr. Rogers here, he wants the magistrate, and he said, throw him in jail. So they threw me in jail, and I missed it. It was a Patriot meeting, the whole thing I was going to. And I missed the meeting, and these people were really mad at me, because I'm notoriously late, by the way. And they were really mad at me until they found out what happened. Now, we went into that, and I think we had at least this many people. They literally would change courtrooms because we were so notorious. Now, I did not intend to become or get notoriety. As he said, my evil twin brother and I have been locking horns with the government for a long time. Neither one of us ever, if you will, been cited for anything criminal that you can prove. So although I've been charged a lot, nobody's ever convicted me of anything. And it isn't that they don't try. It's just that I seem to have divine protection. I seem to be able to run interference just by opening my mouth. I have had, in this case with Judge Bull, the opportunity to ridicule the judge. That they kept me all day in this detention cell through the night, and the next afternoon, and promptly just before the judge goes home, they bring you up, and they've got me in chains. Now, this is not an arrestable offense. Now, I didn't know enough about the law to bring that to the forefront, but I asked him the one question that was designed to really blow his gourd. is what's the nature and cause of the accusation. And of course, if you've ever been into court, if you've tried to figure this out, it can't be the ticket, because that would then be the ticket. And it can't be the complaint, because that would be the complaint. The nature and cause relates to the fundamental. And in this case, it turned out that I never did, and I never have, put another tab on my pickup. And they were so worked up over this, they put a sign on my pickup, "Do not tow." Because I sue people, they think. And you ask these questions all the time. In any event, this Judge Bull made it his business of trying to railroad you through. So he'd say, this is arraignment. You're here to enter a plea of guilty or not guilty. And so I thought, well, that's rather strange. What if I pleaded insane? So I asked him. I said, how many pleas are there? He said, 2. You're guilty and not guilty. I said, well, might as well ask the question. Could I plead insane? I said, well, of course you could. I said, well, that's rather strange. You tell me first there's 2 things, now there's 3. Perhaps I could plead nolo contendere. Well, yeah, you could plead nolo contendere. Well, you tell me there's guilty, not guilty. Now I can plead guilty, not guilty, insane, and nolo contendere. What if I pleaded non-assumpsit? Oh, wait a minute. What's that? He said. And my time to open up to what would say my pool of knowledge came. And I said, well, it means, in essence, no contract. So, well, it's not a proper plea in this court. There's guilty and not guilty. I said, we're going to go through that again? Finally, he gave up, and he said, this is Judge Bull's jurisprudence. And in my audacity, I said, could I have a quote on that? This is another one of those cases that got dismissed. What happens is there's so much notoriety in here that they don't like all these people in the courtroom. And they'd show up, and the judge would be murmuring to the clerk, well, we've got a full house this morning. And she'd say, no, they're all with him. We had a fracas in Scott County, Minnesota, south of Minneapolis. A gentleman had tried to elude the police officers, who was a patriot, but a drunken patriot. Did fairly well until he lost control of the vehicle and got stuck in the median in the mud. So the cops SWAT teamed him, but in any event, the whole thing boiled down to that we were to be there to aid him, and that's what we had put it at. The news media hears about this, and we're greeted at Scott County Courthouse with newspaper photographers, TV crews. I mean, there's all sorts of reporters. The local gendarmes panicked, and they canceled the hearing. They cordoned off the courthouse and canceled the hearing because Rogers were here. Now, we've never done anything, so help me, never sued anybody in my life. They think I have, but I haven't. So there you sit. And they've canceled it, so the notoriety gets worse. Local, they weren't calling us posse. I don't think the name had been invented then yet. The local, I would say, legal or paralegals show up, or local paralegals cause dismissal. But they didn't dismiss it, they dismissed her to continue the hearing. Happened to us later on in federal court. They literally put up, what we say, search stations. And the whole idea there was to educate the juries. And we had a couple of lawyers that were actually going to do this, where the law says that all persons have a right to be secure in a person's house's papers and effects, and that no warrant shall issue for search purposes without stating with particularity the probable cause. Nonetheless, we went in there and we used this as an argument. This is a major federal criminal trial. And the question now before the U.S. Marshals is whether or not you have to submit to a search as a condition of attending a public function. And their assertion is that the judge ordered us to do it. So now you can challenge the judge's order. No lawyer would do it. I mean, I'm sitting there, I'm not going in. And if I'm a defendant, obviously you're going to get me for contempt for failure to be there. And that's what I wanted everybody to do. There's 20 of these guys, or 16 of them. And nobody had the brass to do it. I mean, when the chips are down, they all bet their lawyer's going to get them off. That's the way it goes. But to do a false witness defense properly, it requires you to do a little bit of understanding what the officer is sworn to uphold. In our jurisprudence, every judicial officer, every legislature, state and federal, and all executive officers, state and federal, are sworn, Article 6 of the Constitution, to support and defend the Constitution of the United States. That's the ultimate article they have to uphold. If you ask them the question, and they are upholding this here law, they could never jail you lawfully, because the law would be the same thing. Is this criminal investigation? So let's say the young lady, they're asking her for a breath test, underage drinking she's suspected of. All she really has to ask him is whether or not this is a criminal investigation. If it is, would you punish me for exercising my right not to be compelled to give evidence which would be used in a criminal case? It's that easy. So it's not rocket science. Now you can switch it around. I've put the judge in the spot. And he said we was another mortgage foreclosure type thing, and I had been running the show. They think I'm a lawyer. So I'm in there, and there's at least 6 or 8 defendants. This is pre-trial, so we're in judge's chambers, and this judge is just really being a tyrant. So I decided, they look at me or look up to me to do these sort of things. So I decided we're going to take a recess and regather our wits. So that's what I tell him. We're going to take a he won't let me testify because I'm not a party. I'm only assisting somebody. So I said, well, at this time we're going to take a recess and make this determination, and just got up, and so did everybody else. Everybody in the courtroom was left except the judge, who's shouting and babbling like he's really angry. We're out in the hallway, and he sends the deputy county attorney out there, and the judge comes out there, and he says, Mr. Rogers, come over here. He said, if you interrupt my court again one more time, I'm going to hold you in contempt. I said, I dare you. Now, I told you, I'm very arrogant. The problem is that the right of the assistance of counsel inures to you, and he swears an oath that in all criminal prosecutions, nobody can be denied the assistance, otherwise there's no point in the oath. And of course, if you follow oaths, and swear not at all is probably the most powerful tool in the patriot community and the least used. And the key to it, of course, is not embellishing your response. In this case, these guys were losing this mortgage foreclosure action anyhow. And what we were trying to do is enter or cause reversible error. And reversible error is denial of counsel, denial of a fair hearing, denial of witnesses, denial of evidence, anything. Now, I know it sounds bad, and I've had lawyers that cuss me for doing this because I try to interject error into the record, whatever means is possible. We put in a motion for a fair trial. And got it denied.
Oh, yeah.
It was rather bizarre. It was even more bizarre than it sounds because we had put in at least 20 other motions in the case. And this particular judge was coasting. I mean, he's hungover. And the prosecutor finally gets a glint of what we're doing to him. You literally are setting him up for the kill. No matter what happens, it's heads I win, tails you lose. So you've got all these motions in there, and I learned this from another paralegal. And it's basically shuffle everything you give to the prosecutor. So in other words, you got 20 motions. They're all loose leaf. Bind yours and bind a copy to the court. The judge has got his in order. Yours is in order. The prosecutor's got the shuffled up end. Right? And of course, he doesn't know what he's reading, and he never does his homework. So even though you served this on him a month before, he still hasn't looked at it. And it usually works once on each prosecutor. But they are rather gullible. Or they'll make a complaint. I can't find my way through this. And then you ask him, how long have you been out of law school? Isn't the first thing you're told in law school to be prepared? So now you aren't going to make any friends in there, but if you have juror members, although you won't have them in there at that time, you'll at least make some points. They'll understand that you're not just a pushover. So now the rest is easy. For instance, we teach, I should say the idea is to use what other people have brought forward. So for instance, we acquired some information with respect to subpoenaed evidence. So the policeman stops you for a radar ticket, and you don't have to be bright to do this. You immediately get a hold of the sheriff and the court, and you indicate that you want the evidence impounded in a criminal case. Strangely enough, the radar unit and the police car are no longer on the street. Now, they got two choices. They can contaminate the evidence, which is now inadmissible because it's tainted, or they can continue, right, and it'll get thrown out on appeal. Now, we've been doing this across the country. In some places, it's extremely effective, especially if it's a small town that has one police car. They can't take the heat in that sense. Now, it does not always work. Don't expect them to, fold up and collide just because you said so. I have seen it that way, where you actually put in the motion to dismiss for, failure of, I want to use the wrong term for it, but a proper prosecution. And invariably they come back and they want you to prepare a brief for that. So now you can point out that every member of the state executive is sworn to uphold all of the executive functions and to not interfere with the judiciary or the legislature. And that's true. It's called separation of powers. When the policeman issues a citation, is he performing a judicial function? Considering no warrant shall issue except supported by a probable cause, oath, or affirmation. See, what would be the result of not showing up to answer the ticket? They issue a bench warrant. The law, and I don't remember the case offhand, cannot be used to punish the claim and exercise of a right. And you have a right to believe. Well, I'm sorry, I could have went so close, I guess. You can't punish the claim and exercise of a right. So here's the policeman at Curbstone Court issuing process. And almost all citations say that the undersigned being duly sworn. Do you think you swore him in? Or do you think another policeman was there and swore him in? Only a judicial officer authorized to issue oaths could swear him in. You don't give testimony before an executive officer from an executive officer. We did this in a little hick town in southern Iowa, and the judge looked at the prosecutor and says, "You tell him what's wrong." And of course, the prosecutor says, "Well, the statute allows that we can prosecute by citation." The judge says, "That's a lie." The prosecutor says, "What?" He said, "What you're going to have to tell this man is that every time the policeman wants to issue a citation, that we are going to have to from now on call a judge. It's called a probable cause hearing. And it cannot issue a citation unless there is an affidavit on file indicating that." Now, it's not quite done that way. In fact, I've never seen a police officer go to a judge. Let's see, if they were going to get a search warrant, he'd go to a judge. The same indicia are necessary. Now, there are some case law that indicates that because an automobile's mobility and its ability to escape. Now, here's the kicker. If it's involved in a crime, that would be true. But what crime is there in driving too fast? Okay. Now I carry a driver's license. I know a lot of you don't. But I do a little bit different than what most people do. I carry what they call a commercial driver's license. And I use a commercial driver's license for a valid purpose. It's so that I can allow them to make a liar out of me. So you'll always ask the policeman, and he'll never forget you when you do this to him. So the policeman stops you, and here comes the sirens. And he says, I need to see some identification. I go through this ritual. In fact, I have a real bad ritual that I use. I carry a piece of plastic for idiots, morons, and half-wits. Are you asking me for a piece of plastic? Now, he doesn't want to volunteer, but he'll write this down. And there's a reason for doing it. It's because you're going to ask him to give you immunity for lying. See, I carry a commercial license because the word license, as Peter pointed out, is permission granted from a competent authority to do what would otherwise be unlawful, illegal, a tort, or a trespass. If that definition has any validity at all, then the application for a license is prima facie evidence that you intend on involving yourself in a potentially criminal activity. Right? Now, because I have a commercial license and I understand that the use of the public property, i.e. the highway, for profit and gain to the detriment of the public is a regulatable activity. The problem is, coming to visit you people is not regulatable. So now you submit the question to the police officer. Are you asking me to lie? Are you going to tell me that I have to lie to you by saying that I was involved in an occupation for which a regulation applies? I'm going to a patriot meeting. In other words, you understand what an assembly of the people is? The right of the people to peaceably assemble shall not be infringed. If you follow the Miranda case, it says where rights secured by the Constitution are in question, there shall be no rulemaking or legislation which would abrogate them. I would suggest that this abrogates that exercise. Now, if I were to tell you that I was using this license in this manner, you could prosecute me for perjury, because I'm a liar, plain and simple. Under no conditions would I ever misconstrue the law to indicate that using the motor vehicle to attend the church of my choice, a political rally, or visit my grandmother, or get groceries, or go to work is in any manner a regulatable activity. He'll write this all down, and he's really upset by this time because you call him a moron, a mental midget, and a half-wit. And when he writes it down, he'll say, "But, Your Honor," he'll put this in the back of the ticket. He'll say, "Your Honor, this man insulted me, and he was very uncooperative. So now you've got the evidence." Right? What did I say? Well, you called me a moron and a half-wit. I said, "Well, excuse me, could you rephrase that? Did I not ask you that, or relate to you that I had a piece of plastic that was applicable to morons, half-wits, and idiots? Didn't I say it that way?" Because what you're doing is making a record. Now you're going to ask the court for immunity. And I would readily get on the stand and lie if you'll give me immunity. But you're asking me to admit that I was involved in a regulatable activity for which the crime is perjury and the penalty is 10 years in prison. Now, which would you prefer? So I do carry a commercial license. And by the way, I can handle almost anything on the highway except buses. Everything else I have triples, doubles, tankers, hazardous materials, which is the field I was in. And so there's no mistaking why I have a license. Now the problem is I never do that. Right? So I actually choose my, battlefield. instead of them being able to give me a ticket for no driver's license. And by the way, I've never paid a ticket since I started doing this. So it pays. Most people do not want to face the wrath of the appellate court. This guy is asking for immunity and you won't give it to him. You're going to convict him of being a liar and there's no proof. Because the law doesn't provide that everyone who's going to visit the assemblies of the people has to license the property or the mechanism in which he exercises locomotion. Just that simple. So it's a little bit longer story than that, but if you're really interested in it, I think they got enough people around you could actually do classes on this and train people how to respond. I had a interesting thing with the grand jury up in Minnesota. They were trying to indict some tax protesters, and the grapevine got back that I knew how to respond by not telling anybody anything. So they elicited my help, and for the most part, these were Catholics up here, and so it's rather easy. You just open up their Bible and say you're going to obey God or obey men, one or the other. If it says swear not at all, or any other form of reply other than yes or no. Don't embellish your response. Could you trust that that was what it said? Do you think the Pope's going to excommunicate you? So you take him up to the grand jury. This guy's name was Don Lewis, this black prosecutor, and he's a fairly sharp character. He and I got to be, what we say, rather well acquainted. Anyhow, he'd bring these people in there, and they all did the same thing. That due to personal, sincerely, and truly held spiritual belief and training, I can swear not at all. And of course, they'd say, well, you better talk to somebody that knows. And they'd take them outside and they'd say, well, we got counsel outside. And about the third or fourth trip in there, they got to know who I was. They said, get him in here. So he takes me to his little office and he says, we're considering charging you with practicing law without a license. And the guy beside me perked up. He says, do you think he needs practice? But they were rather bemused that all of a sudden the grand jury wasn't indicting these people anymore, and they'd have to go select a new grand jury. Now, believe me, grand juries are used as a tool of oppression. If you know the story of grand juries, their original function was to run interference against excessive or arbitrary governmental prosecutions. They were never meant to be the tools of the prosecutor. They were meant to provide a bar between you and the government. How many people have heard that before? Very few, but a few. If you have the opportunity to get in front of a grand jury, one thing you'll notice is that the prosecutor runs the show. So I usually ask that the prosecutor be removed. And most grand jury foremen, if they're of the typical type, will immediately disagree. And they're going to say, no, we want him here to ask questions. So now, is this an inquiry of we the people? Or is this merely the federal grand jury? Notice they're not grand juries anymore. They're county grand juries, they're federal grand juries, but they're not grand juries. And the pettit system is equally bad. We exposed this real bad in just a little traffic case, which was, like drunk driving or whatever. And what we wanted to do was bribe the jury. They said, well, you can't do that. No, that's a crime. I said, well, wait a minute. We're not asking to bribe any more than you guys are. But you guys are paying these people $12 a day. We want to pay them $12 a day. Now, they didn't think it was funny. They were really upset because what you were telling them was too obvious. Have you noticed that the prosecutor is paid by the same people who pay the jurors? That the defense attorney is paid by the same people who pay the jurors? And it's all paid in the same type of non-identifiable money. I mean, how many people ever look at this thing? I think somebody was saying before that nobody wants to know anything about money. There's a gentleman in the back. That's not true. In fact, one of the easiest ways of defeating a criminal case is eliciting what, if you're found guilty, would be the compelled substance. And they'll say, what? Oh yeah, you see, you guys don't take tires and all I've got is a backyard full of used tires. I said, well, go sell the tires. Oh, okay, I got a guy that's got too many chickens. I'll sell tires for chickens. How many chickens do you want? See, what's the law say? Either this is under law or we're not. Maybe we're under grace. And they'll take chicken shit instead of my chickens. Worth more in some cases. But nonetheless, how would you adjust the judge? In other words, the question is now, what would you compel me to sell my labor for? I'm willing to be an indentured servant for the length of time necessary. What would be what I have to exchange my labors for in order to satisfy the law? I don't have any Federal Reserve notes, and I don't believe in the Federal Reserve. Last time I met them, they were, I don't know, some derelict on a train. They said they were the Federal Reserve. I never did identify with them. I tried to get their fingerprints. Told them I got with shit on my hands. You cannot identify with a graven image and stay in this very long. If you can be compelled to deal with a private corporation, then there is no such thing as a ban on involuntary servitude. It's like making you all become Catholics, or all Mormons, or all Jews. You can't be compelled to believe in that particular structure. And it is a belief system. I think I was telling a guy back there before that if you believe in Baal worship, and most people would deny it immediately, then I'd ask you to introduce me to the corporation you work for. We had the misfortune of doing this at a bank foreclosure in Nebraska some years ago. And we had wrote a letter to the sheriff saying that we wanted the foreclosure stopped, that we would accommodate the bank with whatever funds were necessary to do so, and that you had my seal or my sign or the signature sign of my nature on this document as evidence of that. The conditions were we wanted the bank to be there, the sheriff to be there, the gentleman, this is Smith in this case, myself, and then they had to name what the condition was, what kind of money they wanted, because we had all kinds. We show up, and I give the sheriff the key to the lockbox in the trunk of my old beat-up Cadillac. Made quite a show of it too. But he was quite pleased. He said, well, this sounds like a fine day. I said, oh, this will be great. I think Mr. Smith deserves to have some rest after all this foreclosure hoopla and ruined his reputation. When's the bank get here? The bank's so-called representative comes up and says, I represent the bank. I said, no, you don't understand. That's not the deal. The sheriff was informed, and he agreed that the ones that would be here was Mr. Smith, myself, the sheriff, and the bank. Oh, he could bring you with. But if the bank ain't here, he ain't getting in that box. Now, the problem is that just they go on vapor lock. And, of course, the news media is there. And then they say, I'm playing word games. So I said, look, you guys are far more intelligent and far better informed than I am. I only wish I knew how it is that you recognize this bank. I don't know that it isn't existing, but if it is, surely you can offer me some physical evidence. See, it's written that in the end times they'll be given strong delusion to believe a lie. I think you guys are lying. Not me, though. I'm a compulsive liar. I do it all the time. Nonetheless, I'll take you at your word. You'll provide for the bank's presence, and we'll provide you with whatever the funds are that are necessary. And they went home sorrowful. Now, he still had his farm, because the media's there, the hype was there, everybody that was wanted. And you can't get him to open his mouth because he thinks he's lucky. So he was lucky, he was blessed, and he made a curse out of it. But nonetheless, I think there's a lot of people out there that if they could recognize this, and keep in mind that the illusion is so powerful. I think it's found in Revelations, it says, in the end times, were it possible, even the very elect would be deceived. If the very elect could be deceived, how much more so us? It's real easy to deceive us. And I admit it, I'm probably the most deceived among all of you, because I've championed what? I've went out and collected money for the government. I've done all of the heinous things. I even paid usury, which is a capital felony. Now, if you wanted to get into the money argument, the easiest way, again, is to identify the substance, or, as I do, I offer to pay the national debt. We got a camera going, I'll pay the national debt. And before anybody says, what are you going to pay it in, keep in mind that you first have to know what it exists in. It's like asking me to break pop bottles. You know, I don't know if your dad's been called pop and whether or not he has any bottles. I really don't. It's a word game, and it's self-deception. I think Peter calls it verbicide, but it's legal suicide too. If you have an opportunity to pay the national debt, we should put at least one of what it consists of on the table, and we'll provide the multiples. Now, I can do that myself. I don't have any problem with that. But if I offered to pay the national debt, what are you guys so worried about it for? Why do they concern themselves with all this legislation concerning the national debt? My body is worth far more than the national debt could ever be, or yours is, or any one of you. Why are they so intent on doing this? So offer to pay it. Now the key is that some of us are obligated not to keep an unjust weights and measure. So a weight great and a weight small shall not be found among you. What would happen if you kept that as a matter of law and held your servants to it? Now remember, you didn't take the oath, all of your elected officials and servants did. And the oath they took amounts to a defection from the government of God into the law of man. So they get their protection from your law. And so they get limited immunity for certain acts done in their office, etc. You, on the other hand, have no such allegiance and no such obligation, save your failure to trespass with somebody else doing the same thing. So it works very well. In fact, if you want to set a judge up, you ask him the question point blank. He'll say, in most people's concept of court, and you're going to have to forgive me if I ramble, I'm not prepared for the speech, I'm just having a good time. If you get the judge in this predicament, and he says that the plaintiff here is moving against you, let's say the plaintiff is the city, and you ask him, in the same sense, upon what individual do you rely for your authority, that in the event I'm found not wanting in the righteousness of my activities, that whatsoever is sought from me is brought upon my accuser. And you'll find that they can't answer you. In fact, there's a case out of this state that says, I think it's Briscoe versus LaHue, that says police officers and prosecuting attorneys are immune from prosecution for their activities. Now that's only partially true, but as it's read, most people misinterpret it. As long as you call him a police officer or a prosecutor, he is immune. What would happen if you said, look, I had lunch with the city of Chicago last night, they didn't mention you? What would happen? Who would show up to represent the city? Is there a penalty for non-belief? What would happen if you would not ascribe to the concept that you're the defendant? What if you said, God, you guys are blessed. You know things that I only dream about. How can I become a defendant? Doesn't require an accuser. And why do I have to say that I am? Why would it benefit me in any manner to say that I was the defendant? See, doesn't that recognize that there's an accuser? What if you just said, I didn't accuse, but I would uphold the right of anyone to have his day in court? Now, who says I'm the defendant? It works marvelously, by the way. And you'll see all sorts of prosecutions decline. Now, it's also a good way to get a Rule 20, which in our state is a trip to the mental hospital. That's not the end of the world. You'd be surprised how practical that is. We had a friend that got a trip to the mental hospital, and he called on me as counsel. And he enforced it so rigidly that they wouldn't even talk to him for his regular interviews unless I was there, which means at 8 o'clock at night, if they were going to do a head trip on him, they'd call me up and I'd drive the 90 miles down there and he had to let me in. Now, it took us a while to get that far, but he would neither eat anything nor speak to him without counsel, and they kept him there for, I think, 60 or 90 days. And so it takes a tenacious individual to do that. When it got all said and done, I mean, he didn't follow through on it, but when it got all said and done, he had enough evidence to prosecute the whole bunch. Because they're only doing it because some judge orders it. Now, if a judge orders a mental evaluation, it has to be done based on evidence, not an opinion. And he's not a medical practitioner. His opinion and 75 cents to get you a cup of coffee. But that's all they'll get you. So you have to understand the power of witnessing. Most people don't realize that you're the witness against yourself as soon as you say you're the defendant. The law says thou shalt not bear false witness, and I might add, against yourself. So every time you say that I'm a taxpayer, or I'm a speeder, or I'm a defendant, you may be in error. I don't know. So most of us are so deceived we cannot fathom anything more than what we've been told. It's the product of the public school system. They come out with an extreme handicap. If you went into an income tax, let's say, case, for instance, and let's say that you were one of the blessed few that have never filed and didn't have a Social Security number, although it's almost impossible to find today. Most of us are dirty one way or another. But if you finally decided to not bear false witness, what would happen when you got to the form and it said, I certify the foregoing to be true and correct, given the fact that you could swear not at all? What would you put there? So you can't modify the form, it's a crime. By the way, the law is the form. The regulations are the rules. But you change the law, and you're not qualified to if you add anything to that form. You have to certify that the foregoing, including all of the government's printing, is true and correct. First error is certified. It's more than yes or no. Can't you be believed without that? Say I get 1728 of 28 USC. Is oaths in or out of the United States? What would happen if you didn't know what a citizen was? Let's postulate that the Creator is coming tomorrow morning and you say, I'm a citizen of the United States. You say, what are the indicia to qualify you? And then you come around and you say, I'm a citizen of Illinois. And then you can say further that I'm a resident. And most people never fathom what they just said. I use the euphemism, if you will, that I'm an individual in the exercise of right. Now, the reason I put it that way is because it's a bar to any other inquiry. Okay, because how may I help you is the next response. You say, what do you say? Oh, where do you live? Do you presume I'm dead? I live wherever I am. Well, where do you get mail? Well, today if you sent mail to this room, I'd get it. Where do you usually get mail? Anywhere I am. Well, where do you get your telephone bill at? Never get one. Don't have one. I had a real interesting experience. I was in a deposition when Peter's talking about, and they asked me if I had a telephone number. And I said, you really want the truth? And of course, what do you say? No. So I said, look, here's the way it is. I hire for use by payment in advance the telephone company's equipment. For that use, they apply an account number. As soon as I cease purchasing the use, they give the number to somebody else. So it's their number applied to my use. Did you want me to say it was my number, and why did? So you get all sorts of weird results with this. It's whether or not you have a liability to labor, involuntary servitude, if you will. When you fill out your 1040 form, do you sign under penalties of perjury? And why is it plural? See, what is the penalties of perjury? Well, see, one is if the judge looks at the form. By the way, only an officer can sign this form, and you're a self-assessment officer. And your occupation is truck driver, and then at the bottom, it's obviously got to be an officer. So he knows he's got a perjure in his hand, and there are plural penalties there, one for the office and one for the person. And then if you say that you're a resident, have you any idea why you say you're a resident? Why couldn't you be a sojourner? Why couldn't you be a stranger? Why not a pilgrim? Okay, the largest sense of where you're at is called shelter. You're receiving shelter in his room. So why don't you shelter? See, home has a legal connotation. Residence, abode, all of those terms in the law, if you will, their law, statute, is construed to effectively corner you. So why don't you use clean language? It says in the end times he'll give you a new language. You could start early. You could just agree that you're deceived. You're so damn dumb, a box of rocks has got an IQ 10 times what you have. Now that we got that established, what else don't you know? So it's real easy. I'm not a driver. I drive my wife nuts, that's true. And I drive home appointed rhetoric, that's true. But rarely could I ever call myself a driver. At best, I'm a keeper of the distances between the ditches. I rarely transgress that because it's not convenient. But I have been known to go through the ditch once in a while. But it makes sense. There's no need, and actually your life becomes a little bit easier if you don't fill out all these documents you're sent. So how would you fill it out if you ascribed to that law and said that literally the word signature is alliterated sign of your nature? How would you fill out a document now? What is your nature? And why would you want to put it in print? Is there a penalty for not knowing how to write your name? I have the neatest signature I ever see, if you want to call it that, is a straight line. When they ask you if that's my signature, I say my signature is so easy to duplicate, I couldn't tell. But how you make your mark is definitely important. In fact, on most 1040 forms, they provide a box for witnesses. Now, it's true that I'm a rather strange individual, but if I were to write a complaint using that theory and not wanting to sign anything, what would it sound like? How would you, it would say, enter evidence or make somebody aware of a problem if you weren't signaturing things under oath? How do you sign court documents? How can you get a complaint in, an affidavit, if you will, if you can swear not at all? So these are real dilemmas. And it means you definitely have to change what you do and how you do it. And you have to change before it's too late. Tomorrow, it's too late. What would happen if you just tried this once? For instance, if I were writing court process in this state, it would sound something like this, and this is not verbatim, this is off the top of my head. It would be, we the people of the state of Illinois, by the hand of Dwayne Rogers, in the exercise of right, make known the following for whatever purpose. And usually it's to serve another. So it would be, for instance, the policeman stopped me. And so now the purpose now is to protect him from the penalty for violating his oath of office. Now when you get down to the bottom, you say, the foregoing was by the hand of Dwayne Rogers, and further, Dwayne Rogers says not. Now, there's no signature on that, and yet it takes 2 witnesses to overcome it. So there is a method, but you have to be able to think about it. I always tell Peter you have to internalize this, and it makes a difference how you view things. I have audacity usually to discuss this with lawyers. The number of lawyers that I work with find this at least strange, but there's a couple of the public defenders in Minnesota that actually use my material. Because the police officer stopping somebody on an alleged, trouble call. For instance, they go to your house. Invariably, they want in your house. They want to arrest, if it's a domestic dispute, they want to arrest one or the other of the spouses, and they hide behind this 911 number. Now, do you realize how easy it is to invent a call? Now, these guys aren't bright enough to do it very much, but it's been the occasion to happen. But what would happen if, when the officer arrived, you ask him who he was looking for? But if he can't tell you who he's looking for, how can you help him? It's the same thing. If they stop you in the street, we need some identification. Well, who are you looking for? Well, I don't know. How can I help you? We have a gentleman in Texas. Texas has a statute that if you fail to identify yourself, it's an arrestable offense. So there's a catch to the statute, though. It says if you fail to identify yourself after having been lawfully arrested for another offense, it's an additional misdemeanor. So it's like an enhancement statute. In any event, he went to court with a lady friend of his, and they immediately set upon him and asked him what his name was. And he told them his name. They wanted to know what he was doing there, and he said, I'm here to provide counsel for her. That's what she's asked for. And he said, well, we need to see some identification. He says, no, wait a minute. I already disclosed what I was doing, and for your purposes, what my name was. So they brought him into this little tiny cubicle, and this just is a recent event, and they, powered his knee in between his groin. He said he almost barfed and vomited. Then they choked him down, and they arrested him for failure to identify himself. So we got their testimony back, and the testimony plainly says that he told them what his name was. And then he refused to show him identifying materials, as if you're supposed to carry a driver's license. As my son always tells the cop, if you want to know who you are, look in your back pocket. If you can't find that, we'll send you home to your mommy. She'll show you where it's at. It's rather a bizarre thing. We've had the opportunity to teach a number of young people. I think there's a school in Texas that actually teaches one of these law courses like this. It causes all sorts of hassle too. But I don't know if it's I don't think it's Waco, but it's in that area. It's not too far. They actually teach it as a course in high school. What would happen if you decided not to, comply in your own prosecution? So every time a document came to your door, you sent an inquiry back as to the reason, the probable cause, the nature and cause of the accusation, who's making the inquiry, and what the penalty is for not responding. So we teach people even when you answer the phone. You say, hello, how may I help you? And they say, well, this is John Smith down at Smith Collection. Sorry, can't help you. Hang up the phone. Works like a shot. And then when they get into court, they say, well, every time we call, they hang up. I said, well, excuse me, what was the dialogue? Well, they said, hello, how may we help you? And what did you say? We said, I'm John Smith, Smith Collection Agency. And they said, sorry, can't help you. And it sounds hilarious that you have to look at him sort of strange and say, well, what's the matter with that? They asked if they could help you. You told them what you wanted. They said they couldn't help you. I learned this from a gentleman who calls himself, of all things, I am truth. And I'm really starting to believe that this character is really something else. He's got a lot upstairs. He's a former engineer, as far as I know, and he run afoul of the law over some rinky-dink ticket. And he couldn't believe that his sworn servants would go to that extent to punish somebody who was merely trying to see that the law was imposed. So he started what they called the I Am Embassy. And the key to the embassy was, if you had trouble with government, he, as the true embassy that you wanted, would run interference for you. Nothing wrong with that. And I talked to this man many times, and I found him totally fascinating. His logic was impeccable. The only flaw was they kept throwing him in jail. Now, that doesn't make him wrong. And he never committed a violent act. The policeman attacked his car numerous times, and they literally said they pinned his car to the curb. And in so doing, of course, they wrecked 3 police cars. Well, why did you pin his car to the curb? Well, he wouldn't stop. Well, what was he doing that you were trying to stop him for? Well, we knew he didn't have a license. And this sort of thing. Now, Illinois has got some frightful laws on the books when it comes to arrest and the necessary criteria for probable cause. And yet you've got a powerful state constitution if they just leave it alone. But they amended, I don't know how many, 600 amendments to this constitution, something like that? Oh, that's California that's got that. I mean, it's nuts. And they're going to keep doing it. Now, the underlying thing for this is you don't have to know a lot about law to do this, thou shalt not bear false witness. You do have to know a lot about you. And you do have to be able to think on your feet, which means there's 3 rules that I was first taught are be quiet, don't say anything, and shut up. Yeah, works like a charm. Now, once you start doing that, then you turn around, instead of responding, you inquire. Because etymologically, answer is and swearing. Swear not at all. And certification is more than yes or no. Declaration is more than yes or no. All of a sudden, all of this mumbo jumbo disappears, and you got a clean language. How may I help you? Oh, I need your name. Oh, my mother gave that to me. I'll keep it. Thank you. Well, what else can I help him with? But do you follow how easy that was? Now, they'll think you're a smart ass. So there's a time and a place. Now, you can do such things as I would be unwilling to cooperate with you without the assistance of counsel. Okay? So now you don't tell them anything. Oh, what do you need a lawyer for? Excuse me. I wouldn't be able to cooperate with you without the assistance of counsel. I didn't say lawyer, but you don't have to say that. Let him babble. But it's really a very fluid method. It's non-aggressive, and it is, it's very insightful to it. It'll bring out the wrath in the best cop. Is there any questions? Can I, we'll do that for a bit. I think they'd ask me if I wanted. You got to get to the microphone first, though. He's going to stick this tube in your nose. Air in you.
You click it on. Other one.
Don?
Yeah.
Yep.
You mentioned the Texas law that you have to identify yourself. For years, I've been telling people before they got a hold of me, even when they got a hold of me, that Texas versus Brown 1978 says you don't have to identify yourself to a police officer. Therefore, when you have a license plate on your car, it tells them who you are. Everyone got thrown out of court.
Yeah, you're exactly correct. In fact, Texas is notorious for its, even Miranda, Texas, it's notorious for its high-sounding, moral-sounding rulings, and yet they turn right around and violate it every day. But no, you're correct. Brown versus Texas is the case. This guy had an opportunity. His girlfriend was with him, and obviously she's the one that elicited his help, and yet they charged him. I mean, what an opportunity to test this one in court. Now, he'll walk away with substantial sums, I would hope.
You also mentioned the LaHue versus Briscoe. What I did was reverse on that. I would prepare the document with the court's address on it, and I would put down the citation, the policeman's office number on there, and I specify that he's right under. He solicited me with an unverified complaint, and I would ask the judge. I said, "Would you mind if he signed this? He's waiving his immunity." And he says, "What do you mean?" I said, "Well, I'm just asking you to waive your immunity in case you commit perjury." They won't sign it, so I just tell the judge, "Well, this man's going to lie on the stand. You got to dismiss the case."
Theoretically, he should dismiss it, and in fact, sometimes he will, although the immunity is a bar in office. See, perjury in office isn't permitted because nobody can qualify the office. We had a lady who was charged with perjury, and this is kind of a neat deal because it went into trial. This is a major felony, 2 counts of perjury, and she would not accept licensed counsel. What she wanted was me to assist her. And because she'd been an associate of mine for some time, she knew some of the terminology, and so every time they'd ask her a question, she'd say, "I would be unable to participate without assistance." And they would respond, "Well, do you want the public defender's office to ask questions for you?" She said, "I would be unable to burden my fellow countrymen with his expense." Right? Because it's a crime to do that. Well, the statute provides that the court can appoint you counsel. She says, "I didn't ask for you to appoint me counsel. I asked for my own friend to help me." Well, he's not a licensed lawyer. And of course, they won't let me talk because I love that argument. But she kept repeating it. The prosecution was so upset, and the judge was so upset, that by the time they got through, they picked a jury in about 20 minutes, all 12. And perjury. 10 years in jail. Heavy duty. And she had the courage to stand up and say, "No, I will not burden my fellow countrymen with the cost of this court-appointed prosecutor or prostitute." Nonetheless, the jury was laughing at her, most of them. But the prosecutor was so confused and so upset that he violated every rule, if you will, of procedure by asking the jury whether or not her antics would upset them and seeing as how it wasn't their fault. Okay, so what he was saying was that the defense here has upset the schedule, and we don't want you to blame us for it. It was her fault. It's not ours. So he already prejudiced the jury, and I sat back there knowing this, and I'm just grinning like a, fed cat. I just had my last mouse, because this guy's dumber than a box of rocks. Nonetheless, then he asks only 2 questions of potential jurors, and those questions are whether or not you'd hold this against us, and whether or not you could find fairly. What kind of a question's that? But he was so upset, and of course then the judges say, you have a right to voir dire the jury, and she said, well, I don't understand what that means, but my friend here does, and he'll help me. No, you can have the public defender's office provide you with those questions and that information. I'm sorry, sir, I would be unable to burden my fellow countrymen with his expense. And this kept up all the way through. So the prosecution's got its 3rd witness now. By the way, the witnesses are 2 lawyers, a court reporter, and a judge. Against her, this is heavy duty, and it's a court transcript. This is a heads they win and a tails you lose proposition, unless we can cause reversible error. Finally, the judge is becoming incensed because of her obstinacy, and he orders the public defender's office to go talk to her. So he comes over and he says, what do I do? The public defender does. Now, they don't hate me. They know me well enough to know what I'm doing. And I said, well, okay, let's go talk. We go out in the hallway, and I say, here's the deal. The only time I want you to raise an objection is in the interest of justice. Don't you dare say you're going to represent her. Don't you dare say you're going to appear for her. You are going to do no such thing. But in the interest of justice, any court officer can intervene. That's the role you're going to use. We're breaking for dinner, and this guy is so airheaded, he just leaves. His name is Tim Johnson. He's not really a bad guy, he did dumb shit. Anyhow, we go to lunch, and they're all sitting there talking, and the jury's sitting over there in the corner, and Karen and I are sitting up there, and they're all talking about her and pointing fingers and laughing. And what they don't know is that on that jury, because of this prosecutor's stupidity, is the county's best-known tax protester. And he's going to convict her. So I'm quite confident how this is going down already. Nonetheless, not only on that, there's a druggie on there. I mean, this guy's got earrings and tattoos and nose holes and blowholes and everything else. And he's been in there, and he is not going to find against her. So I've got 2 allies in the jury that nobody knows about. But anyhow, we're getting in there, and so Karen decides she wants to enter some evidence from the record that wasn't on the list. So just ask him. Just tell him you want to do this. The prosecutor's dumbfounded that this judge, who is now rattled because I'm there and she ain't doing what she's supposed to be doing, lets her read this letter into evidence. And the letter is indicative of the her previous lawyer's direction to her to do or not to do something. So basically, she couldn't be a perjurer, because the lawyer told her to do it. And they've got this other lawyer on the witness stand, and all of a sudden it dawns on the prosecutor what's going on. The judge just goes ballistic. And of course, recess is called again, the jury's sent out, and they into the chambers, and this place is vibrating. And it's noisy in there, but they won't let her go inside. They got the public defender in there, and they got the prosecutor in there, but she, who the matter's over, and all of a sudden the judge comes out and says, we want to see you in the hallway. So the public defender comes out and says, they got a problem, they want to dismiss. I said, okay, no, you don't know anything about that. What you want to know is what's going to happen to you. They said, no, they're going to dismiss. I said, no, you don't understand. If you remain naive, you have a much better chance of surviving this. What you want them to do is dismiss with prejudice. Like, this is faulty charges. Go back into the judge's chamber, come out with a smile on. I mean, it's like I thought of something, right? But anyhow, this woman having enough courage and knowing the concept of counsel. Now, counsel is not a representative. Counsel is not anything more than you make it with assistance. I tell them, the judge, this way, appearances are deceiving. And I can misrepresent as well as represent things to you. Along with the verb side, I turn it around. I say if counsel is a synonym for attorney or lawyer, then we should be able to interchange all of those words. And it's true that I can counsel with my attorney. And it's true that I can counsel with my lawyer. It just doesn't sound right when I say that I can lawyer with my counsel. Or that I can attorney with my counsel. See, they are not interchangeable. If you read the law, it says in all criminal prosecutions, the accused shall enjoy the assistance of counsel, in this case, for his defense, in his defense. Assistance obviously modifies counsel. So you could leave counsel off and still have a sentence. So now it'd read, in all criminal prosecutions, the accused shall have the right to enjoy assistance in his defense. So you can see it's not enough. When you point this out to them, they're usually flabbergasted. Peter had some excellent cites out of the counsel issue. One that I use, and with impunity, is Argensinger v. Hamlin. Argensinger says, without a doubt, let every judge in the land know that when a trial with misdemeanor starts, that no imprisonment may be imposed even though local law permits it, unless the accused is represented by counsel. Now, this is found in every state law as a federal case, which means that you cannot lawfully be jailed if you understand how to use counsel. Now, it's not that easy. There's enough judges up there that will say, well, you can represent yourself, and if you fall for that one, that's what you'll do is fall. Or you can make your own appearances if you fall or appear for that one. He did too. Peter pointed it out that representation and appearances are not interchangeable either. And in the larger sense, counsel is that exercise which is protected against encroachment by law. Now you get back into Miranda, which says, where rights secured by the Constitution are in question, there shall be no rulemaking or legislation that would abrogate them. How much time we got?
No, for you legal freaks out there, that's Argersinger v. Hamlin.
Oh, yeah.
It's 407 U.S. 25. 407 U.S. 25. Argersinger v. Hamlin, sheriff.
Excellent case, too, by the way. Now, the key to the counsel issue, though, is exercise, and you have to keep it in mind. Assistance is an exercise. If you do it the other way, there's so much case law that they will use against you already. If you fail to do this properly, in other words, if they say you're going to represent yourself and you answer yes, you hung yourself. You need to stay natural. I don't understand what you mean. I tell them, this is my verbiage, I tell them I'm willing to prosecute a defense. But prosecute is what I mean. I'm not going to stand here and let you, whatever, roll over me. When I say prosecute, I mean exactly that. And they say, well, you have to follow the rules. I say, I've read your rules. In Minnesota, that says, these rules govern criminal prosecutions in the state of Minnesota, and this is a verbatim quote, for felonies, gross misdemeanors, misdemeanors, and petty misdemeanors. Say nothing in there says a thing about defenses. So the gloves are on. You guys got rules, I got to prosecute a defense. And I'm good at it. So hang on to your hats, because this one's just begun. And they think you're arrogant until they start seeing what you're doing. Now, I'm not good in the sense of paperwork. It's reasoning. So everything is postulated in the form of a question. They can never answer the question of law, so they can't proceed. Upon what individual do you rely for your authority, is what you're saying. Because there shall be a remedy in the law for every injury to personal property or character. If that be true, then what I want is the individual accusing me of whatever injury to stand forth and be given his remedy. Would you deny him that? So you just turn the whole thing around. There's nothing left for them to do. Now, they do roll over you anyhow, so recovery is also important. In other words, how do you facilitate a recovery? Appellate court work is strictly privilege. You petition, and a petition is always from an inferior. I wish we had the time. I don't know what time we do have.
Yeah, about 20 minutes to the hour.
Okay. But another issue that should be opened up is this concept of taxes, and applying this false witness defense to it, because taxes are based on titles. All taxes are. And this concept of income as a tax, if you will, initiative. There's a lot of people who went to jail for tax protesting. I would suggest that you'd be better off reversing that trend and go to jail trying to pay a tax. It would be far too bizarre for these people to understand. If you tried to pay a tax as a matter of law, you'd be faced with two obstacles. The first of which is the scripture requires that you not, if you will, bear false witness, which means that unjust weights and measures is a false witness. That if you attempt to, if you will, discharge in equity that which is payable as a matter of law, you've just deceived yourself and left a stumbling stone for your children. Your servants, on the other hand, are too stupid. They'll take anything in the nature of commercial credit that looks good to them. I mean, I think somebody was giving out POMCs for years, and then they started with certified, certified money orders. And then Common Title Bond and Trust, Roger Elvick's organization, did much with bank drafts. And all of those are valid, if you will, instruments of commerce. The problem is, it's not commerce you have to be worried about. It would be much easier to quit identifying yourself as a taxpayer and start identifying yourself as being a truth teller. So, how may I help you? So the tax or deficiency adjustment comes, or I should say it starts at the employer sense. If you're soliciting a job, obviously you need an employer. Now the problem is no employer creates an employee. It's always the other way around. All employers are created by employees. Like I've never seen Honeywell or 3M, First Bank, go out in the street soliciting you. You create the image and you're going to pay for it. Once you elect to become an employee, you violate another law, which is that you should not, if you will, debtor is servant of the lender, and you should not, if you will, stand bond for anybody. I think scripturally, I think they call it, I can't remember the terminology anymore. In other words, you're not to be surety for anyone. Because you're technically bringing into existence a non-existent entity, and you're going to withhold from your family 2 weeks of your labor, when the scripture plainly says that the laborer is worthy of his hire, and he's not to go home without his clothes and have his pay each day. So you create this problem yourself by eliciting an employer who will believe you. And to pursue that, or to ensure that belief, you give them 2 weeks of your labor. Why won't they pay you 2 weeks in advance? You're not to be trusted. How many of you have stolen from First Bank that they shouldn't trust you? See, it's the other way around. You give of yourself and what rightfully belongs to your family, and you don't tithe, that which is to go to the Creator. You don't give, you don't provide for a knowledge of the law, if you will, a keeping of the commandment, and instead you submit yourself to Baal worship. I would bet you that every one of the Baal priests died firmly believing that First Bank, or I should say Baal, existed as they went over the cliff. Every one of them. So the blind truly cannot see, and the thief cannot hear, and the ignorant can't help but be ignorant, or they wouldn't be. They were aware of what they were ignorant of. So it's still a truism. When you create this problem of fiction, and you set it up and raise it up above you, you become the tail and they become the head, which fulfills the scripture. And worse, now you take from them promises to pay. The dictionary defines a check as a promise to pay money. When you go to the bank to negotiate this instrument of credit, what do you get? Oh, you get notes. Well, even less. It doesn't even promise to pay. Well, technically it's an obligation, but it doesn't have the indicia to make a valid note. So what you get is a circulating medium of exchange. Currency refers to time. A circulating medium of exchange that's current, in time. But it isn't money. It can't qualify as a just weights and measure. It can't qualify as money because Title 18 United States Code says that Federal Reserve notes aren't money. Kind of interesting. So Federal Reserve notes are obligations of the United States to the same extent as are canceled United States postage stamps. If they were money, they would say they're money. It says this note and not this money.
Yeah, but they're redeemable in lawful money.
Not so. If they were redeemable in anything, they'd have to indicate that substance.
Contract.
Well, contract is another, I call it an invalid use of the law, because under agreements, you don't have to have a contract. Yet under contracts, you have to have agreements. So following that concept, if you and I exchange a property, what we have is an agreement. If you and I agree to exchange a property, we still only have an agreement. Contracts only come into view when one of us violates the agreement. So when you make out a contract, it's prima facie evidence you intend on violating the agreement. Simple. So why involve yourself in it? It's like an employment contract. If you're a laborer worthy of his hire, why should I worry about you? I do it this way. My house doesn't have any locks on it. The reason it doesn't have any locks on it, and I don't care who comes in either, by the way, is because I was given this house as a blessing for my labors. Should I deny those who need shelter? Or should I call you a thief? Okay? And make you knock? Okay? Only a thief would have to knock to see if anybody is there so he could break in. Anybody in need of shelter would merely come in and accept the shelter and thank me. That's not hard to understand, but you start living that way, all of a sudden you'll see that if at 8 o'clock tomorrow morning you wouldn't steal, or better yet, you don't think I would, you don't need door locks. And I put the entire Schlegel lock business out. Better yet, there'll be no police officers. If I don't steal and you don't steal, he don't steal, who'll steal? What do you want a police officer for?
Police officer.
So you hire police officers because you think I'm a thief. So the reason we have laws is so that we have a reason to keep the police officer employed to make sure this thief here doesn't break in. What would happen if you just said the law as commanded, thou shalt not bear false witness, which is a theft, by the way. If I take your property, I'm witnessing falsely that it's mine. So they all are summed up, and I use thou shalt not bear false witness as an exercise, as a easy method of showing that all of the laws are the same. You could say love one another, and it's loosely the same commandment. But let's go further. The government of the United States entirely, and Illinois included, would be out of business tomorrow morning at 8 o'clock if we only kept the one commandment, thou shalt not steal. Simple. It's because we want to think that we're thieves, or that you think that I'm a thief, that you keep these laws on the books, policemen on the street, and all of the rest of the paraphernalia that goes with it, just because you think I'm a thief. Now, keep in mind, I am a compulsive pathological liar. On the other hand, when's the last time you caught me stealing from you? And believe me, I've been around enough houses, enough burglars to know that they never go to a locked door. They go to a piece of window called glass, and the only one you slow up with a glass, or excuse me, with a locked door is your neighbor or somebody in need who's honest. And all he feels is slighted that you wouldn't honor the creative intelligence that allowed you to earn this place of refuge and deny it to him. Makes sense to me. Which, by the way, this drives my wife crazy. Because at all times, you can come into my house at any time, you find strange people sleeping. And strange enough, I've never, ever, and I told this to the sheriff, no one's ever stolen from me and lived. The sheriff said, "Did you kill somebody for stealing from you?" I said, "Tell me, has anyone ever came to you and said they stole from me?" They're all dead. But you see how subtle that is? It works on you. And if you internalize this, all of a sudden it's no fear. Now, who's going to come into my house that the Creator can't redirect his activities? He's not that stupid. And besides, why do I want to spend my money and my time messing around with door locks that I'm going to lock myself out with? Which is usually what used to happen to me. But in 10 years, no one has ever, what would you say, stolen from me. And I don't mind. We run a rather strange place, but nonetheless, I have a few people now that do this also. A couple of them have been broken into, and somebody run off with a bunch of their, what would we say, toys. And the guy put an ad in the newspaper saying thank you for taking, it was a VCR and a couple of smut tapes. And lo and behold, they showed up again. They just got dropped on his porch. But some people take it seriously. So putting this into practice, I mean, if the kingdom's going to be coming, I think you ought to be ready for it. And of course, I'm anything but religious. Don't read me wrong. I think the law, as practiced in the Scripture, allows you to be you and me to be me, so long as you don't trespass me and I don't trespass you. What could be the problem? I don't find any reason to think you're a thief. Put your hand on my pocket. No, he doesn't do that, and I don't do it to him. So he doesn't hate me, and I don't hate him. On the other hand, the policeman comes around every night and checks your door. I can tell. You guys are secure when the cop comes up. Checks your lock to see if I broke in. Hell, he never checks anybody's lock except the bank. Remember, he worships the fiction, and he's a part and parcel of that. Baal worship is forbidden. Graven images. I'll bet you that the concept of First National Bank existed in the mind of the perpetrator, or I should say the incorporator, before it became First National Bank. If you read the dictionary, you'll find that the term corporation never existed until at least the 14th century. The concept never even existed. When they had them, they didn't know what they were. And then you get into land titles. You love that idea. That takes about 4 hours, though. But land titles are something you guys should hear. It has nothing to do conceptually with allodial land versus feudal land. It has to do with titles and who you think you are. Consider that the Scripture says, "The land shall not be sold forever, saith the Lord, for the land is mine." Who in the hell are you? How did you get title? If there was ever a lawful title to the United States, do you think it was had by good kings of England? Or how about Napoleon? We purchased it from Napoleon, didn't we? How about the Russian purchase of Alaska? Would you think those titles are somewhat suspect? But I'd go over to your house, kick the hell out of you, take your house and retitle it. So they do in New York. It's called a Torrens certificate, but legally beat you out. As long as they can deceive you. Now the problem is the concept of law requires that there's a descent. Power goes down in law. Actually, it goes up if you don't agree. But all titles descend from givers to takers. So you can't be baron unless the king lets you. You can't call yourself the baron. And you can't be a knight unless the baron or the king knights you. Those titles, those terms came across from England, and we're stuck with them today. So most people don't recognize that you have to remove the title, the claim is really what that is, from the land. What would happen if you practice what the churches do and got a tax-exempt status? That sounds like it works, except a tax exemption is an application for a privilege. And privileges are complete with servitude. Say the privilege of the realm. That's what title is. And you can keep the title so long as you perform the fealty. So fee, service, fee simple. You heard those terms. We're still practicing idolatry in violation of it. Look at the Liberty Bell, the Jubilee. Imagine what would happen if you declared a Jubilee. The problem is, here's what my wife said, well, somebody come by and take our land because they owned it before we did. So, you're telling me that theft is okay because it occurs in your house? Well, we'd be out in the street. So, you think theft is justified just because you happen to stumble? Well, I don't want to be out in the street. And I submit that I would appeal. No matter what they did, I'm going to appeal. But you have to put it into practice. So if you kept the Jubilee, I think, I don't know, Peter, do you know when Jubilee is? Somebody told me it was 88 or 89.
Yeah, the three guesses that we've heard are 87, 88, or 89.
But we put it into effect. So you forgive all debts, irrespective. Now it matters little if a fiction forgives you. A fiction can't bill you, how could they forgive you? And then every 7th year, same thing, practice year of release, you'd be amazed how debt-free you are. It doesn't take rocket scientists to figure this out. Usury is the curse. It's one of those illusions. I had my sons very well trained when they were being interviewed by the so-called sociopaths that operate as policemen, what their father does. And of course my son would say, well, if I told you, are you going to imprison him? Now that sounds rather suspicious. And he said, well, no. What's he do? So I tell him, the reason he's not going to tell him is because there's no probable cause. They would go, and in fact, this my oldest son did this the first time I ever heard it done anyhow. It was about 8 or 9 years ago. He was riding a motorcycle, had his mother on the back, and my vehicles are not registered or licensed or insured or none of that other stuff. And his mother was enjoying the ride, and here come the highway patrolman. In fact, this was a Passover. Anybody in here keep Passover? Okay, there's a few. Anybody can tell me what the penalty is for keeping Passover? Is there a penalty involved for keeping it? No. It's a rather strange thing when you think about it. But anyhow, we're at this event, and it happens to be at my farm. And they're raring down the road, and the cop sees all these people there, and he's obviously curious. So he actually strikes the side of the motorcycle with the police car. And fracas ensues, comes out there, and he's angry because my son, although he knows who he is, will not tell him his name. And so he says, we're going to take you to jail unless you respond. And he said, well, my mother calls me son. Now my mother is, her mother standing right there, I should say, or his mother. And she's appalled that why he'd say this. And of course, she's a rather large woman, and the cop's got his hands full. And my little spitball brother, or my older brother, comes by, and he's more than a handful for the cops. And the cop leaves. You know, first they called the tow truck to tow the motorcycle, and of course there's more of us than there are of them, so you keep playing around with them. But in any event, we noticed that the policemen are up there on the highway with binoculars watching the proceedings, and we're having Passover. And the word got back through the grapevine that there's a cult here, which is nice, and they're sacrificing. So, you know, that's rather strange. So the policeman he quit his job sometime later and was talking about this. And he said, what was going on there? And I said, well, what we're doing there is trying to keep the law that we're supposed to keep. And what we're asking you is there a penalty for keeping the Passover? Is there a punishment laid out in the scripture or the law, present or past, that would in any way indicate that there's going to be a hell to pay, if you will, for keeping the Passover? Well, no, that sacrificial law is done away with. So what would you say if the lamb died on its own? what would it be then? Let's say that we're not going to have a lamb until it dies, so we're going to wait till that unhappy event occurs. Would there be any difference? Okay. Do you think having a turkey for Ishtar worship would be any less offensive to the law? So you think the law is dead? Let me tell you the story of the law of the priesthood. And it goes like this. In ancient times, they used to have to burn the Passover skin off the lamb because they made a business out of selling this thing. A lamb without blemish. Now, the reason it was a lamb without blemish is because would you offer your family dog shit? How about just the scum off the top of the stove? Or would you give them the best? It is your family. And in this case, this is a feast in honor. It's Yahweh's Passover, the Lord's Passover. It's in His honor. It's a commemorative event. And you're to keep it as a feast through all your generations. Now, is there a penalty for doing that? And this cop comes up, and he said, well, you sacrificed this lamb. I said, well, why don't you come over there once the next time we have chicken roast? We do that every year, and we have fish at the same time. Do you think the chickens don't die? What happens when you cut the throat of a chicken and he bobs up and down? And of course, we live on a farm, so this is done every day. You want fresh chicken, you don't go to the grocery store, you go to the yard. Give me your chickie. But nonetheless, they're just as dead, and they sacrifice their lives. Now, strangely enough, they need to, in order to be raised. If nobody ate chicken, there wouldn't be any chickens. That's the thing. There wouldn't be any Brahma cattle if nobody rode them. Brahmas don't taste good, they're tough. So they usually raise it for a specific purpose. Everybody that's eaten chicken has had it sacrificed pursuant to the priestly code. It's called the USDA. Like you can't buy chicken in any store except USDA approved. It's USDA graded. It's whatever they're going to give to it. It's unauthorized, if you will, altars called chicken plants. And they bring them in and they do it in a ritualistic manner. If you've ever been to a chicken plant, they start by dragging them out of the batteries, which is what the vehicles are called that they're in, and they hang them upside down. They never run chickens through on their feet right side up. They hang them upside down in a ritualistic manner. There's an inspector there that watches so that they're not treated with cruelty. Then they're run through a 25 to a 50,000 volt machine that shocks them, and the bird just sits and shudders. And all in this ritual. And it goes through into a processing room they call a killing room, and by the end of the day, the blood in there is 2 feet deep. And you literally, it's like walking in Jello. I've been in them. And when they kosher kill, it's even better, because the rabbi knows each one. Nonetheless, this is a ritual that they go through, and each one is graded all the way through, and each cut is signified as being approved. Now, you thought the priesthood was dead. You cannot even buy it unless you have the priest money, the temple tithe. You cannot buy chicken in this country unless you use Federal Reserve notes issued by the same temple. You thought it was dead. It's even better when you get into livestock killing. So when they grade out choice and prime, what do you think they do with the fat? Well, they grade that out too. You're supposed to have marbled meat. Do you think there's a reason in the Creator's law that they threw out the sacrifice after the third day? Have any idea what rancidity in meat is? And refrigeration, by the way, is no means to an end. In my sense of the word, now we started practicing the health laws at the same time we discovered the rest of this legal thing, because there's no answer in doing legal mumbo jumbo. I would submit I've read 10,000 court cases, and I probably know a little bit more about the legal aspect of it than most of the people in my area. And I still don't see an answer. So I think it's in thou shalt not bear false witness. Yet this is the most difficult thing to learn, because your everyday life means you got to go to Baal's temple and worship, and at the behest of the priest you use the temple tithe, the temple tax, to purchase your goods. You can't buy, sell, or trade unless you do that. And it's going to get worse too. In fact, you can't use your children as a tax exemption, except you, if you will, figuratively label them or number the mark of the beast. You pass them through the fire to Moloch. You can't claim them as not only as a tax exemption, you have to lie to say that you had income. Yet you couldn't show me what income is if your life depended on it. See, how big is this lie? And how much of the deception are you going to own up to? God, I walk in a very fragile line when I walk in the court, because they know what I'm doing, but they also know what they're doing. So when I say, how may I help you, it's usually met with silence. Nobody wants to. I go around to the restaurants offering to steal. I got in there, I said, you know, I'd like to have dinner, but I don't like stealing that well unless you give me permission. So I give them paper. I tell them, this thing says that it's $10. Now, I'd be a liar if I said it was, because a dollar is a unit of weight. It's that easy. If it isn't a unit of weight, there's no reason to have a weight and a measure. But nonetheless, if you'll let me have that good meat for this piece of paper, we got a deal. And I can secretly laugh at you, or as I do right now, laugh at you. Now, at first it bothered my wife, but can you imagine trying me with a jury, and I bring in all those witnesses that says I stole from them and how I did it? Do you think I could identify what income wasn't? If I owe you $10, it's a debt to me, and if I pay you, it becomes income to you. What is this, a chameleon? And it's getting worse. There's a lot of court cases that say income is profit or gain. I say not so. Okay, because if you and I just agree to do a favor for one another, is there a profit? Let's say the favor happens to be you're going to build me a house. In exchange, I'm going to mow your yard for 20 years. Where's the profit? Neither one of us have a profit, and neither one of us have a gain. We've merely exercised the right to contract, the right to agree. And it's prohibited to the state, unless, of course, you're a resident, unless you're a citizen, unless you're a subject. Did you realize that the word subject is a synonym for slave? And why would you want to claim you were a subject or a slave? The Creator comes tomorrow morning and you're going to tell him you're a citizen. Really? What king do you worship? That's the problem. But I guess I'm going to have to wrap this up now. We're down to 1 minute. And I did want to do these ear candles, but I can do that after the tapes are off also. We're pretty much running out of time. Do we have any time on the ear candles yet?
We got time for some Q&A?
Oh,
We can do a little question and answers. What do you got here? Well, except we need to move my here.
Two questions. One is, on a 1040 EZ form, it says that I certify that this is true and correct to the best of my knowledge. And would that be perjury if it's not true, because you're certifying it's true and correct to the best of your knowledge on a 1040 EZ form? And my second question is, can you lie under oath in a court today, since they're operating under legal fiction or whatever they're operating under? Could you legally lie and not be held accountable because it's a court of fiction or whatever it is?
Well, the last question, you can't lie, obviously, because now you're admitting it. But you can admit you don't know. In fact, there's 3 responses. I don't know, I don't remember, and I don't understand. Will keep you out of every possible jam you can get into. To the first one, the fact that you certify under the penalty of perjury that the foregoing is true and correct, the problem is now is whether or not you're going to embellish your response. See, the certification is more, it's an embellishment, it's more than merely saying that this information is by the hand up. What they're asking you to do is introduce yourself into a controversy. All I'm saying is that what would happen, is there a penalty for declining to do such a thing as to sign your nature? Because that's exactly what you're doing. Now, I'm not saying that everybody should just drop out, because most people will not comprehend this well enough to just drop out. But if tomorrow morning you knew the Creator was coming, what would you do then? Is it time? See, because you're the one that's accountable. But whether or not it's perjury, perjury means under oath, or lying under oath. To the same extent that juror, or juryman, means oathman. The word juror is etymologically oath. Okay, so if you look it up in the dictionary, you'll find that a juror means oathman. So perjury is by, it's per, oath. So anything under oath is in violation of swear not at all. Okay. Swearing and oath is not synonyms. So it's, while you can swear an oath, you cannot oath a swear, because they're not interchangeable. One is the act to effectuate the other. The oath is the result of embellishing the response. That's what you're talking about. Does that answer your question? Okay, rephrase that.
Gotta have a mic.
Oh, I'm sorry. Well, it's important he gets to hear what he wants to know.
Okay, let's say you send a 1040 EZ form and you make a false statement on there, but it says that when you signed the 1040 easy form, it said I certified that the all is foregoing whatever is
Right.
true and correct to the best of my knowledge. So if you make a mistake, could they still hold you
Yes.
under perjury? Why is that?
Well, because he said the best of your knowledge. Then you admitted the mistake. So the only thing you can do then is file an amended form correcting the mistake. So you're going to get caught in this, what we say, box. If you sign under penalty, then you accept the penalty. There's no question of whether or not the facts are true. You said they were. If you make a mistake, it's incumbent upon you, because you're the assessor, you're the self-assessed individual payer, and it's up to you to amend it. Otherwise, it's not a mistake. It's prima facie evidence that you intended. And that's what they'll do to you.
Dwayne, is it not true when you said earlier, and this, Jim, this is an answer to your question, whether it be a 1040 or 1040 EZ, when you're swearing that the foregoing is true and correct, it's not only your figures, it's the form, and everything else is true. Can you swear to that?
Which seems preposterous, but true. Yes.
If you would elaborate or try to summarize for me the false witness defense.
Well, basically,
I'm having trouble with that one a little bit.
a lot of people do. Basically, it requires only that you not, if you will, display as factual or actual that which isn't. So if I ask you if you're a taxpayer and you said yes, how would you, if you will, affirm in a positive sense the substance of that? So what's a taxpayer? In truth, taxes, the word tax means to touch sharply. What, in fact, did you touch sharply, and by what method? If you're using the etymological sense of it. On the other hand, if you were to display that you were a defendant, it's a false witness unless you can identify the accuser. See, there has to be an injured party, otherwise you're self-accused. It's like being self-assessed. You're the taxpayer by definition. What would happen if you wouldn't pay the tax? Would you now be a non-taxpayer? See, by definition. The idea of certification, for instance. Why would you certify it when to acknowledge would be sufficient? Because there's a case, if you will, in point of what certify means. It's an official sense. See, acknowledgments can be taken or given by anybody, but certification is an official act. So you certified foregoing was true and correct. The false witness defense comes in with, how may I help you? I have no information on which to predicate or to substantiate your belief. If you're saying that the form is true and correct and that my information is true and correct, I have no information that would validate that. It's like the guy who says he works for the state. And you say, well, bless you. I admire people who know who they work for. Introduce me. So you're just not willing to be deceived, but you're not lying, or you're not telling them that they're liars. You're not trying to find fault with them for what they believe. You're offering them an equal defense. So you're saying, upon what individual do you rely for your authority? That in the event I'm found not wanting in the exercise, whatever sought from me is brought upon my accuser. It's pretty much that wrapped up. As a false witness defense, you'll find it's a magic time, because now you have to judge what you think you know. I think Michael Brown, one of our good friends, that says it best. It's what you know that ain't so that's causing all the problems. And even little terms like I'm a resident or my address is. Acknowledge the other guy may be in error, but you're not willing to accuse him. That's really what it boils down to. It's damnable if you have to be the judge, because now he's going to have to ask you, are you the defendant? Excuse me, are you not you a sworn officer? Would you require me to give evidence which will be used against me in a criminal case? And he'll say, well, this is a civil case. Oh, all the more so. I'm going on. So there's a lot of things to it. It's really quite easy, but you have to readdress how you think about things. I mean, I find it, to me, almost titillating to watch a policeman respond. I mean, I don't want to go to jail all the time. And like I said, I keep my battle zones winnable. So I never go out soliciting trouble, but I never really run from it either. And I'm remarkably lucky at getting out of it. I seem to go into the outhouse, coming out with roses. Good place to grow them, by the way, auto fertilizer. Any other questions? Or did I answer your question?
Yeah,
Well,
thank
you can get the tape once, and it'll give you will help a little bit. I guess we have nobody at home.
How to stop grand jury indictments?
Well, generally, you can't stop a grand jury indictment unless you have access to the grand jury, or you know somebody that does. For the most part, the grand jury is being misused. So you can offer to appear before it, but it's a rather dangerous move because you lose their so-called immunity. Most of them understand that you cannot be compelled to testify against yourself. On the other hand, if a grand jury is going to indict you, that's only the initial steps, and you can quash most grand jury indictments, particularly in the tax and drug field, because they're, improperly used in that sense. In other words, they have to show there's a tax owed, not merely that you refuse to file. They have to show the requirement. So by the time you do discovery, and there is some access or limited access to grand jury transcripts or grand jury testimony, if you can get a friend in there to testify for you, that can be fun too. We've had good success. I've never lost anybody at the grand jury level yet. But generally what I'd like is about 6 weeks in your head so that I can put you in front of them and then they get instructed. Because this is really a matter of swear not at all. Say, how may I help you? Did you file taxes? Excuse me, I'm informed and believe that the filing of taxes is required by law. They'll accept that. The problem is I cannot lie and say that I had income if I can't lawfully say what income is. Right? Now, whether or not you filed is irrelevant. It's whether or not you had income so that you had to file. They're just predicate things. It's like getting the grand jury foreman to address the prosecutor for what he really is. Are you in here soliciting the prosecution of this man? Mm-hmm. Well, no, we're offering you evidence so that you can prosecute him. Mm-hmm. See, that's a lie. And what we say, that there's a lot of court cases for this, that the prosecutor governs the type of evidence that will be brought before the grand jury, which means that it's not a hearing for your benefit. It's no exculpatory information. It's for the prosecutor's benefit. And if he can convince the grand jury that there's sufficient evidence, they'll come back with what they call a true bill. And now you have to know a little bit more. But you can quash almost every, in fact, get a hold of Michael Brown. And he's been doing this for years and years. But if you can get in early, he can quash almost any grand jury indictment. They don't do them lawfully. And rarely is a conviction had lawfully. If you know you're going to be prosecuted, start learning as much as you can. And then set up the signposts. I mean, the signposts are so that you know at what stage of the trial you have an appellate review coming if you want appeals. Now, I don't do appeals normally because I prosecute defenses. So even at the appellate level, I would automatically, if there's fiction involved, prosecute to the Supreme Court. I don't go through the appellate system, which is frowned on. Everybody says, well, that ain't going to work. Well, we don't know. We haven't tried it. So I would prosecute a defense in the same manner as Paul did. He appealed. In that sense, appeal means prosecute, if you know your language. He prosecuted his case all the way to Caesar. And he won. At least we don't have any record of him being punished for it. So the verbicide has changed the terminology so much, and the public fool system went right along with it. You don't have a chance anymore. But if you think you're going to be prosecuted, what we say, get your crap in a pile. You can't stop them, except you be in obedience to the law. So you can't, if you will, expect protection from the Creator unless you're obeying His law. So it's easy. And once you understand that, then the story is how difficult is practicing the law. Well, how difficult do you find it not to bear false witness? Do you find it incredible that you're not stealing tonight? No, I don't. So I figured that keeping that law is a lot easier than keeping their law. I don't even know if I'm parked right. And they change the law tomorrow. I could have been right today and wrong tomorrow. Yeah.
On grand jury indictments, do they have to have an order? In other words, what summons a grand jury? How do they get convened to look for you first for an indictment?
Well, generally they have prosecutorial teams that are out gathering evidence, and they usually consist of either IRS, and then they'll go to the CID. But they start with the civil division of all things. And then if they see a cause, what they call a cause, they refer to their CID or criminal investigation division, in which case he'll bring it before the prosecutor when he thinks he's developed enough information. Then the prosecutor convenes the grand jury. See, and then they use that. Yeah, the prosecutor convenes it.
Does he have to sign something first?
He's supposed to, but the court will actually use it. He petitions the court. Then the court calls from the jury wheel for the grand jury.
I thought the Secretary of
The Treasury had to authorize that.
Well, that would be the theory. That would be the theory. The only problem with that is that the grand jury is just a tool. See, if you had grand juries, you'd have protection, but you don't have any. What you have is prosecutorial juries called grand, but they're not juries in the sense of the word.
So you said that they need some substantial reason to convene a grand jury. Who signs an affidavit that initiates this through the prosecutor?
Well, normally
Do they have to sign some affidavit like CID or whatever?
they should,
Okay.
but normally that doesn't
Where
occur.
would this be found?
Well, you can get it on the Freedom of Information Act, or you can even do it on discovery if you prosecute them for it.
Okay, but how would you get it by freedom of information? Who would you ask for
You
this?
start with the clerk of court, and you find out where the grand jury is sitting,
Okay,
because they won't tell you who it is, but where it's sitting,
okay.
and how you can communicate with it. And normally you'll find that your communications are restricted to the prosecutor's office. So then you follow that chain of command to the prosecutor's office.
What if they say they won't disclose any information?
Well, that's okay. You're not asking them for information about what the grand jury is doing. You're talking about that which the law provides for grand juries. In other words, it's administrative. You're not asking
How
for
was
evidence.
convening in the first place? What was the...
No, that's open information. That's public information.
How would you get it? You
Clerk of
said-
court's the best place to start. But
For-
generally, it's also statutory.
Okay.
So your rules
There
of
there
court.
has to be a signed statement somewhere with the file with the clerk of courts whereby the prosecutor
No.
was empowered
All
to...
the prosecutor does is say that he's investigating criminal allegations, okay, crime. Now keep in mind that his office is strictly prosecution, not investigation. The investigative team is executive, and most of these people fall prey to this. The prosecutor's office is only prosecutorial. Anything done out of that context is prosecutable. So you can go right after him if he exceeds his office. But it's a very gray area, and most judges, in other words, you win that only on appeal. Oh, good. Smart. But I know the theory.
All right, I'd like to thank, first of all, everybody here this evening, but I think we had a wonderful caliber and quality of speakers tonight. I'd like to give both Wayne, Gary, Peter John, Dan has already gone, but let's give them all a great big hand.